The FBI is currently in talks with several internet firms regarding its controversial proposal that would require them to build a backdoor into their services for wiretapping. The Bureau is proposing an amendment to the 1994 Communications Assistance for Law Enforcement Act in order to expand the agency's ability to conduct surveillance through web companies as well as telecommunications providers. What's more, the FCC is reportedly considering revising this law from its current form to also include video and voice chat internet services. Although there are concerns over the government's ability to effectively do its job in an age of changing communications channels, tech companies, privacy groups, and consumers are not likely to support such measures, especially given the recent reactions to both SOPA and CISPA. So at this time, we're going to bring in Michael Donahue, a partner at the Marashlian Donahue law firm, to tell us more about these recent events. Thanks for joining us today, Michael.
Thank you. It's a pleasure to be here.
Great. Well, let's start just by talking about the 1994 Communications Assistance for Law Enforcement Act. What does it do in its current form?
Sure. At its most basic, the CLIA requires telecommunications carriers to provide technical assistance to law enforcement in connection with the lawful intercept of certain communications. More specifically, what that means is CLIA requires telecommunication carriers, which is more broadly defined under CLIA than under the Communications Act, pursuant to a valid court order, to expeditiously intercept particular communications identified by law enforcement of an identified subscriber, while excluding other communications that are not covered. Deliver those communications to law enforcement in a form that's compatible with law enforcement's equipment and is usable by law enforcement, and to do so unobtrusively and in a manner that protects the privacy and security of the communications as well as the existence of the intercept itself.
So now, in terms of the amendment that the FBI wants to make to it, what exactly would it do?
The specifics, the FBI hasn't provided a specific proposal, but it's provided enough information about what it desires that you can get to the specifics. Basically, the FBI wants to amend CLIA to catch up with changes in technology that have taken place over the last 18 years since CLIA became law. As enacted, CLIA does not cover newer innovations, newer technologies such as social media or peer-to-peer services. In addition, in the past, law enforcement has been willing to develop solutions for entities that don't have a CLIA solution in place. But with shrinking government budgets, law enforcement no longer has the resources to support that kind of activity. So under the FBI's Going Dark initiative, it proposes to amend CLIA in several ways. First, to permit the FCC to regulate technical standards for solutions, and that's based on the safe harbor under CLIA that allows industry to use a industry-approved standard and be considered to be in compliant. But law enforcement has found that the standard may be sufficient from industry standpoint, but it's not from law enforcement. Second, to require the FCC to approve a standard in order for it to be considered safe harbor. Third would be to eliminate or modify the current exemption in CLIA for private networks. For example, universities and other entities that have a private network are not currently covered by CLIA. Fourth would be to eliminate or modify the current exemption for information services like web services in order to bring those innovative technologies into compliance. That would also include social networks, peer-to-peer services, and encrypted email providers. And then fifth would be to provide stronger enforcement of existing requirements that providers that enable encryption are also able to decrypt that information for law enforcement. And finally, to require providers to certify their CLIA compliance annually as opposed to just a single certification currently.
So if this move really would allow the FBI to do its job more effectively, would this proposal simply just be a natural evolution of the FBI's current tools?
In part. The way the FBI has described this is it's to close what it's found to be a widening gap between its existing authority and its ability to get the information that it needs pursuant to that authority. The FBI has made clear that it's not seeking additional authority to request different kinds of information. What it's seeking is the ability to go to a provider and obtain the kind of information that it's authorized to get under law in a cooperative manner. So it's cited two problems with the current structure and the current law. One is that it gets a court order and goes to a service provider who's not currently covered by CLIA and therefore doesn't have an existing solution in place, and then it takes time to develop a solution. Or it goes to a service provider that is covered and has a solution in place, but for various reasons, the company's solution hasn't kept up with its network, hasn't kept up with technology, or is just not capable of providing the full scope of information that law enforcement has requested. So although the Going Dark initiative is directed to new technologies and new services that are outside the original boundaries of CLIA, it's also directed to services that are currently covered, but for various reasons just haven't kept up.
So how big of a problem do you think this Going Dark issue is?
From the law enforcement standpoint, it's a fairly big issue, and there's been evidence provided by the FBI and others that while this was a small problem a number of years ago, it's becoming an increasingly larger problem as more services are moving to different technologies and more innovative technologies that are not currently covered by CLIA, or that fall into a gray area where CLIA may or may not apply. And criminal activities are moving to those types of technologies. From law enforcement standpoint, it is a growing and significant issue.
Well, as mentioned earlier, over the past year, I understand that the FCC has made several inquiries into CLIA. So what can you tell us about these events and what they mean?
Sure. What we've determined is that, as I said in the past, law enforcement was willing to work with providers to come up with solutions, and now with declining resources, it's less able to. And also, at least as described by law enforcement, the mechanisms for enforcement under CLIA and under other statutes are somewhat limited. It puts law enforcement in the position of either trying to come up with a solution and get the evidence, or seeking enforcement, which is often contempt of court proceedings. So there isn't an effective mechanism from the FBI or the law enforcement standpoint. So what they've done more recently is to refer non-compliant providers to the FCC's Enforcement Bureau. And the FCC's Enforcement Bureau then follows up with a letter of inquiry, which is its formal request for information to a service provider. And then it conducts its own investigation into whether that provider is in compliance with its CLIA obligations under both CLIA and under the FCC's rules. Under the FCC's rules, it has the authority to levy fines, called forfeitures, against companies that are not compliant, or to impose other compliance requirements for violations of the Communications Act or the FCC's rules. To date, all these activities are typically not public. They're subject to confidentiality between the party and the FCC. To date, the FCC has not actually issued a notice of apparent liability, but I would not be surprised if that happens sometime in the near future.
Interesting. Well, some privacy and security advocates have already indicated concerns over the proposal, and tech companies are likely going to disapprove of it as well. So do you think that these companies have valid arguments?
Yes, there are certainly valid arguments about the privacy and security issues in connection with an expansion of CLIA to newer services and even to implement the kinds of surveillance mechanisms that are in place for existing technologies. Some of those arguments you could make with respect to law enforcement action under CLIA today. As I said, the FBI has not indicated it's seeking an expansion of its authority, really just the ability to exercise its current authority with new technologies and new services. So I think there are valid arguments on both sides. And I think what's important is that both sides recognize that there are privacy issues and there are issues with network security and cybersecurity and the ability of third parties to obtain access to systems. And so the key is to have a framework in place that addresses those issues and balances those with law enforcement's concerns.
Well, there has been talk, too, that such a proposal would need to include protections for disclosure of any confidential information so that it is not released. So is this a compromise that would appeal to both companies and privacy advocates?
Yes, I think so, and I think that would address part of the concern. I would certainly address the need for companies to maintain the confidentiality of their subscribers' information, their users, and what they're doing with their network. What that proposal will not address, and I think may not go far enough for some advocates, is issues about the ability of hackers to get into a system, or network security. Protections on the disclosure of confidential information won't reach those kinds of concerns.
All right, well, at this point, the FBI's legislation has been approved by the Department of Justice. So what do you foresee happening next?
Well, in the current environment and election year, I doubt there will be any formal action at Congress on these issues. No one wants to be in the position of debating the value of privacy over national security in election year. But I do think that the FBI and other agencies will continue their activities and continue to develop and refine their proposal so that when the election results are in and they can present a formal proposal to Congress. At the same time, I think it's possible that the FCC could open up an avenue for modification of CLIA that will address law enforcement's concerns. The FCC is currently considering expanding its own authority to include other types of services beyond pure telecommunication services, including an expansion of IP communications and IP-enabled services, expansion of its authority over broadband. So to the extent that the FCC does that, it may, either as a complement to that or following that kind of activity, subject those services to the requirements of CLIA also.
All right, well, we'll watch and wait to see what happens next. Michael, thank you so much for talking with us.
Thank you.
You're welcome. With this SOPA News Report, I'm Abby Johnson.